Hello, everyone. I'm Maya Shofany, and I will be moderating the panel on regulatory happenings in Web3. We have some exciting topics to discuss today. I'm going to go ahead and let our lovely panelists give a brief intro.
Hi, I'm V. Lee. I'm a partner and the head of regulatory and policy at Bain Capital Crypto.
Hi, I'm Marc Goldich. I'm the general counsel of Proximity Labs.
Hi, I'm Sarah Brennan. I'm the general counsel of Delphi Research and Delphi Ventures.
Hi, I'm Chris Donovan. I'm the GC at the NEAR Foundation.
I'm Richard Muirhead. I'm managing partner at Fabric Ventures.
Awesome. So we have about 5 lawyers on stage, and then Richard, he's outnumbered. So one of the first topics we wanted to talk about and hit on is very controversial right now, especially in Web3. So NFTs, exciting, fun, but are they a security? So Marc and I were talking about this a bit before we got on stage. And I wanted him to kind of walk you guys through Dapper Labs and the case, some of the rulings that recently happened, and also maybe we could hit on some emoji talk.
Some emojis, yeah. So this is a case, there was a case recently. It's a putative class action, which means it's not quite a class action yet. It has to be certified by the court before it's actually class action. And this was a case that was brought by a private individual against Dapper Labs, alleging that Top Shot moments are securities and that they are unregistered securities and bringing an action based on that allegation. So you may have seen recently in CoinDesk, The Block, and various other crypto news outlets about this decision. It was widely misrepresented that the order and the court just decided that Top Shot moments were unregistered securities. That did not happen. So if you have some moments, you don't have to quite worry just yet that you purchase some unregistered securities. What happened there was a motion to dismiss. A motion to dismiss, basically, which is filed by the defendant, is to basically challenge the complaint and say that the plaintiff has not brought a claim that a sufficient relief can be made for, right? So what happened was the judge there decided that, yes, the plaintiff did state a claim. The plaintiff did state enough to pass this very preliminary stage in the litigation. And what the news outlets really attached to was the fact that, well, in so doing, the judge said, these look like securities. They could be securities. There's a plausible claim that they're unregistered securities. Look, are they going to be deemed securities? We're going to have to see what happens with that case. If I had to pontificate, I would say it's more likely than not. But right now, they're not securities. This was just a motion to dismiss in a private litigation regarding securities laws. Now, Maya mentioned emojis, right? And maybe one of the most fun things about this case, and cases aren't always fun, but this one at least had some pictures in it, right? Because the judge looked at the various communications, right, from Dapper Labs about the moments, and how did it convey what these moments are? Did it convey it in a way that there would be an expectation of profits, so that these could be deemed securities? Well, guess what? There weren't that many, at least, allegations regarding what Dapper Labs said regarding these moments, being investments. However, they did tweet a lot, and in their tweets they used emojis. And these emojis were like the rocket ship emoji, right? And the court actually did a pretty thorough analysis in stating, these rocket ship emojis, these graphs that are going up, they all are very indicative of, a communication that these are investments that will rise in value and that will profit, right? So this was really the first time, I think, that we've seen any court look at emojis and go into this great length about how they can convey something and make it such that one prong of the Howey test could be satisfied, not by words, but by emojis. So, we should all be a little bit more careful, I think, with our emoji usage.
But I was going to say, Mark, also, I think it depends on the context,
That's
obviously. You know, if it's related to a financial instrument or if you're talking about a product that is related to some, you know, higher yields, et cetera, then it makes sense to opt out of using those emojis. But if you're just saying a random statement that
That's
has...
right.
Yeah, you could still
Completely
use the rocket ship.
Completely context
Yes.
dependent.
Okay.
You know, people are very reactive. So after this decision, you know, I know lawyers in the space who looked at this and they said, "Oh, I was right. I told my team never to use rocket ships, you know, and don't use rocket ship emojis. And we have a ban on, you know, the chart go up, you know, and rocket ships." Well, I think that's a little overreaction, and you know, I don't think that anyone should really ban the use of any emojis internally in any business. I think it is very context specific. If you were going to tweet about this panel, for instance, and you had the rocket ship emoji next to it, no one's going to think that you're selling a security, and it's okay.
For example, hashtag use rocket ships responsibly.
That's
that
right.
would be a great tweet.
That's right.
But thank you so much for laying that out for us.
Yeah.
I think we want to segue a little bit into a more intense topic, Gensler. So we're going to have V here, who used to work at the SEC, talk to us a little bit about the Kraken case, and maybe we could open up the discussion to the rest of the group to discuss what happened with Paxos and what you guys think that was all about. But V, do you want to kick it off?
Yeah, so as you guys probably know, last month the SEC sued Kraken and they entered into a settlement where Kraken agreed to shut down permanently its staking as a service program and pay a fine. So this is the first SEC enforcement action involving staking. So here they allege that the staking service that Kraken provided to customers was a type of investment contract that should have been registered under the securities laws. So I think it's important to just take a step back and recognize that there are like different types of staking, right? There's self-staking, which is something you can do yourself by setting up a validator, locking up, you know, some of whatever asset you're staking, whatever asset associated with the protocol that you're staking on is. So that's self-staking. I think that is fine. There's nothing in the SEC's order to suggest that that might violate the securities laws. But of course, staking as a service, these programs that Kraken provided and that other centralized custodial platforms provide, like Coinbase, like Binance, and others, it's very different. Well, it's not very different, but it's different in the sense that, you know, if you're a customer, you're handing over your assets to this provider, and they're staking it on your behalf. Kraken's program was, you know, it was run in a particular way, and there are certain features of it that the SEC pointed to say that, in particular, it satisfied the efforts of others prong of the Howey test. For example, you know, Kraken guaranteed a certain percentage staking reward to its customers. And so in order to do that, what they did was they actually carried out strategies to smooth the yield that they were offering or the staking reward that they were offering, as opposed to, say, just passing on whatever the true network rewards of the protocol were. Some other things they did were they allowed you, I believe, to withdraw your staked assets at any time, as opposed to, say, you know, your ability to unstake your assets being dependent on, you know, whatever the lockup parameters of the protocol are. So those are the kinds of things that the SEC cited to say, actually, this is very different than self-staking. Kraken, you know, engaged in all of these entrepreneurial, managerial, technical efforts, and that's why it satisfied Howey. And so, I mean, I think the question is like, what can we take from this? What does it mean for other staking programs that might differ, right? In some of those ways, what does it mean for staking in general? Like, what does it mean for liquid staking? Like, you know, protocols like Lido Finance, where you're locking up your tokens in a smart contract, and then you get like a wrapped version of it, or a staked version of it, and so that you still have that liquidity and you can use it, but while still earning staking rewards. So there are different versions of this. I think it's hard to say what we can, what it means for the rest of sort of like
the industry
types of
as a whole.
staking.
Yeah, because I know that they clarified in the complaint that it's around custodial staking, right? They said that Kraken's product appeared to be more like custodial staking, where we can't necessarily say that about other staking products out there, and it's not clear like how Gensler will proceed in the future with other staking products. So
because even among custodial staking programs, there are differences too, right?
Yeah.
So it's hard to know what to take from this one enforcement action.
Yeah. So that's super helpful. And I know that the SEC has been coming up in the news a lot lately. We had the huge Paxos incident, also New York DFS. Sarah, I know we were discussing that a little bit too. Do you have any take on what happened there with BUSD? And
well, I think that in that case, the only thing that I'll say is I think that there is, in my opinion, a little bit of redundancy because I think DFS handled that really well. They're the regulator on the scene. They have like a permissive regime where there was like boundaries of behavior that they had allowed, and so in that case they like stepped outside of it and they came in and said you don't do that, and they handled it. And then what we have like regulators swarming issues a lot, and I just think it does cause confusion. And I just think like in terms of coherence, when you look at like even like when I look at the Kraken situation, if there were things that you could learn from that before you get to remedies, shut it down, and promise never to offer this product again, like if you want to dictate clarity to the market, if there were things that they could have fixed, that would have been a lot better of a solution or something to pursue. But it doesn't make me super hopeful if the remedy is shut it down forever for other people in the market.
Right. What could Kraken have done could they have registered this product? We don't know. There's no path.
Yeah. I heard it makes sense for their business to have, not fought the situation, given the market share. So, but I do want to open up the discussion a little bit more and expand to other jurisdictions. We have Chris, and he specializes in UK law as well, and would love to hear about what's happening there. I know on a positive note, the UK is asking for the industry to respond to a crypto consultation. And they have 3 specific chapters in the consultation that hit on DeFi. And I wanted Chris to kind of talk to us about it a little bit and share, what he learned about it and how we could all be involved in it, because I think it's actually a great way for the industry to make an impact in advance versus like what's happening to us right now on the U.S. side.
Yeah, thanks, Maya. I mean, I'll let the U.S. folks comment on the current state of the U.S. Market in a minute. I know there's a lot of strong thoughts about that. But in the UK, things definitely feel more optimistic. I think there is a bit more good faith interaction from lawmakers and regulators. The new Prime Minister, Rishi Sunak, is quite keen on our space in general, and I think he views, that there's a lot of opportunity to encourage developers and users of the technology to the jurisdiction. So to Maya's point, the Treasury in the UK released a consultation a couple of weeks ago setting out proposals and plans about how they want to think about regulating our space in general. And I think it's a phased approach that they're taking. So they're focusing initially on stablecoins and the activities around the custody and issuance of stablecoins. But more generally, they're taking an approach where they're thinking about the regulation of activities rather than underlying assets, which I think makes a lot more sense than some of the things that we're seeing in the US at the moment. And to Maya's point, I think one of the most significant things about the consultation and how it's been structured is that, the approach that they've taken is essentially, look, if you're doing something from a centralized perspective with digital assets that looks a lot like a TradFi equivalent, we're going to regulate that. And I think a lot of people would think that's fair and reasonable. But what the proposal also says is, well, look, if you're decentralized we recognize that actually that probably requires a different approach, right? We can't force that into the existing regime that presupposes centralized intermediaries that we can gatekeep and regulate. And they're essentially saying, look, we don't know what to do, so can you as an industry, can you help us out? Point us in the right direction. And so to Maya's point, it's a great opportunity for everyone here who takes this stuff seriously and wants to try and push regulation in a helpful and engaged direction to make a contribution. And so the foundation is going to be submitting a response to that consultation. LexPunk as well, that I know a few of us up here are involved with, are also going to do the same thing. And there's a really good opportunity to advocate for a disclosure-based regime. I think in particular would be a really fantastic thing to try and achieve. And I think in the UK, because there's a real desire to embrace the technology, I think if if we put forward an effective proposal, there's a really good chance that it gets considered seriously and maybe even makes it into the law, which would be a fantastic outcome.
Yeah, I actually really loved the way they worded some of the questions. Within the questionnaire, they were asking, what do you think as an industry the regulatory challenges are? What do you think is the path to decentralization? So they're really giving us a very big opportunity here to influence that. And yeah,
one thing I was going to add is, which is a great thing to see, they explicitly state in the paper that they don't want to regulate developers, right? Which, again, is not something that is necessarily a view that's shared in the US right now. And one other thing that I wanted to mention that I was talking to Sarah about before we came up on the stage is, LexPunk have put out an amazing regex safe harbor proposal. And I think that's something that, it is very much worth putting to the UK regulators. And I don't know, Sarah, if you'd want to talk us through how you guys thought about, pulling that together and what inspired it to.
Sure. So after years of talking past each other, the industry and regulators, about what a securities regime or what a workable path to issue tokens might look like, a group of lawyers in LexPunk actually got together and wrote what we'd like to see. And the paper is a Reg CF, Reg A sort of mashup that if you don't meet sort of, it's the safe harbor is based on Commissioner Peirce's safe harbor that we iterated upon it, but basically the decentralized enough test, or the gloss on Howie, what we thought that looked like. And then if you wanted to do a token issuance and you had not hit the safe harbor, you'd sort of opt into a securities offering wrapper, and it'd be an exempt reporting regime. And if you did an issuance, we go through it kind of in depth, like what we'd like to see. You'd get to offer to retail. We talk about the disclosures that we'd like to see. We lock up insiders and like pre-existing whales like VCs, so they're not dumping on retail within like a 12-month window after the issuance. And then it's kind of like a ongoing disclosure and reporting regime until you hit like sufficient decentralization. If you don't, you're kind of reporting forever. And if you're in compliance, you can like do another issuance. There's like going to be caps, of course. But we tried to be very thoughtful in like what accommodations we need in existing law, when we could use law that, like, and make analogies and use as much of the existing cloth of law that we can, and then only ask for accommodations when we felt it was really necessary. And so we sketched that kind of, soup to nuts, but it's only supposed to do an initial issuance and then like allow peer-to-peer trading. If you're doing like a listed offering on a centralized exchange, we kind of dropped off there because that looks a lot different, frankly. So, we've been talking a lot this year about potentially adapting that for a UK regime, and what it looks like with centralized exchange listing and what we'd like to see in secondary market disclosures.
Thank you for that background. That's super interesting. And Richard, do you feel like that would be something the UK would be open to working on and participating in?
I I'm sure they would be in general, but I just wanted to first say, this is probably the longest I've sat listening to lawyers without being overly tempted to interrupt them on a call or elsewhere. But actually, I'm feeling very comfortable in the company of so many because my parents are both lawyers, maybe that's why, and I am saving up for our own general counsel. And then maybe they could be here. And the point about that is that you folks are the experts, specifically in the law and the regulation, how it's playing out. But maybe I can sort of add some color in terms of the opportunity that comes as a result of this current regulatory landscape. So 10 years ago was when I first got involved in the space, and pretty much the first investment I did, not quite Bitcoin, a couple other things, was in Bitstamp. And we went out there to do the due diligence. They had a small army of people doing their KYC and AML in a room, and with lots of passports left and right on the walls and the whole thing. And we asked them kind of like, well, how do you know that that's actually kind of working properly as a kind of a process? And they said, well, all of these people here, we know they're all from the same village as us, so we can trust them. And my point about that is that what we need here and what we're experiencing in the way in which compliance and regulation is unfolding is a fundamentally different trust model. We're going from that, if I can call it, village-based trust model to, you knew your bank manager, to something that was based on centralization and protection of privacy most of the time of data, and then you identified who people were. And we also need to move to a different regime for this, the decentralized world, and that's non-trivial. But anytime there's something that's non-trivial, there's opportunity to be found. Opportunity to be found, on the border between looking after people's privacy and ensuring that things are compliant. On the border between, delivering financial freedom and inclusivity and making sure that we're not mis-selling financial products to people who don't understand them. And we like to say, actually, at Fabric, we look for founders who are kind of on the border between relentlessness and recklessness. And obviously, we've seen a little bit of recklessness in the last year. And I think, we'll continue to, there'll be opportunity at that point for people to tap into. And there's been maybe picking up on some of the points about whether you regulate developers or you regulate businesses and so forth. One way it's been summarized, I think, a little bit, it's a bit soundbitey, is like, don't regulate the protocols, regulate the apps. And there's also been a sort of a claim that if we want to see come to fruition this kind of global nation, which is quite borderless, that we can't put any of the smarts into the protocols. I'm not sure, actually, it's the beginning of a debate or it's an ongoing debate. I'm not sure that's true. I think that's exactly where the opportunity is to build some great systems that are able to marry up the technology with indisputable facts and with however different regions and apps need to adapt to deliver compliant systems. That's pretty complex, but that's the opportunity for entrepreneurs.
I think also our industry has been, keeping those things in mind, because some of the things regulators think about are like privacy, security, and as we're building and as these young entrepreneurs are building, a lot of the technology is aimed to build a secure network. It's aimed to have privacy. But I think there's like a disconnect in conversation often between like the regulators and the industry itself. But I really liked your input on that. And
let's face it, there's a huge disconnect between our industry and most of the rest of the globe still at the moment in terms of the opportunity.
That's very true.
Even like the FT in the UK, which we love as a publication, but they're not exactly crypto friendly.
Right.
And we've been trying to pitch that to them for the last 5 years, and we need to continue.
They don't like our space very much. No. But there is also quite a big geopolitical competitive element to what's going on right now as well, right? Because a lot of different jurisdictions are jostling to get into the pole position to attract our space in a positive way. And I think the UK right now is seeing that as a really big opportunity for them, and they're kind of the next paradigm of innovation, right? And I wonder, like, a question for Marc and Sarah would be your perspective as US practitioners, if you feel like the current environment is is pushing a lot of projects, developers out of the jurisdiction, and whether that kind of it undermines the very the very policy objectives that this regime is meant to be trying to achieve.
Yes. The U.S. is not fostering innovation, full stop. And projects are leaving. They're doing it out of necessity. No competent team that's in DeFi is going to, make their protocol available to the U.S. There's going to be geofencing and geo-blocking the U.S. as well as sanctioned countries. So it's a sad state of affairs, but it isn't reversible. The way I see it reversing is by looking at the UK and looking at the EU and seeing what they're doing. They are trying to foster innovation. They are trying to have this true come in and talk mentality. And what's going to come out of that is a more hospitable jurisdiction for teams to operate in and for projects to be built in. And it will be some time before it happens, but the US will wake up, will realize that they lost an opportunity, and at that point they'll probably change course. But at this point, in my opinion, that's not the direction things are going.
I'll ask you a question. So, I would posit that the folks in the UK are not geniuses or particularly entrepreneurial. To some degree, you could argue it's driven by necessity because of Brexit, which might have been an act of self-harm, possibly.
Yeah, maybe.
So what's going on in the US? Why systemically is this happening?
It's become politicized. It's
It
become
definitely has
politicized,
become
and we have some very hostile regulators that have made very clear that they're not open to this type of technology, and that they don't, in my opinion, care about decentralization. I do think for U.S. teams and for the space in general, we always should just go back to base principles and look at what is this technology, what's it there for. It started as dissident tech. It'll always be dissident tech. It's a feature, not a bug. There are obviously mainstream use cases. There are amazing things that can be done with this technology, but it started as dissident tech, and we should always go back to decentralization and that's a really important part of the technology, and we should foster that. And that's why I'm excited about a lot of what's happening as a result of the hostile environment in the US and in other jurisdictions around the world, because it really pushes the developers to find new solutions, right? And to re-decentralize and to not re-intermediate. And we see that today on this stage. Panel after panel has been discussion over this new technology stack, BOSS. BOSS is built on this premise that users should be able to access this technology without an intermediary. They should be able to run this technology locally. Front ends aren't really front ends. They are on your computer. You're running it locally. And I think that is where this space is headed. That's where the space should have always been headed. And sometimes it takes a hostile environment to survive and to find the right path forward. And I think that's where we are. So when I look at the climate, I see the silver lining being that this is what the technology is for, and it's prevailing, frankly. And we're doing, our job at, LexPunk or in our various positions with our organizations, trying our darndest to really get through to the policymakers around the world, not just the US, to understand the benefits of the technology. And nobody asked Sarah and this group of lawyers to put together Reg X, soup to nuts, write a statute. But you have this great community of developers and lawyers who are working together, thinking about these issues and putting together this great work product, and hopefully it'll be acknowledged and adopted in some form. And, we've seen with Hester Peirce and some other policymakers, they've cited it and as an example, and that's nice to see. But we would really love to see it adopted. We'd really love to see the policy statements and the different policy works that we're putting out to be viewed and utilized. And I think what UK and the EU are doing is great because they're actually asking for this to be done. So we're happy to, and Chris has been monumental in this for LexPunk and in connection with LexPunk, working on some pieces that are directly related to that effort. So it's just great to see, when in these environments, not only does the technology thrive, but I think the people do as well.
So in lieu of that, Marc, I just want us all, I want to, go through everybody and just see what you guys think the policy takeaway for the year is. We're still, in March now, actually, but just want to hear from each of you's perspective on what the focus will be for the year.
Can I just do one really quick
Go ahead.
follow-up comment to what Marc was saying? So all I wanted to say is, as an American, and working in this industry, the thing that makes me really sad is that I feel like the US is really squandering its first mover advantage, which is a really huge thing when it comes to any kind of technological innovation or just innovation in general, right? A lot of category defining companies over the last 5-10 years in crypto have been US-based companies like Uniswap and Coinbase and Circle and OpenSea. And so instead of taking advantage of that and creating compliant pathways for these kinds of companies, these kinds of projects to exist, I think we are ceding that to the UK and the EU and more countries in Asia. And that's just such a shame. But
I can't agree more.
my policy takeaway for the year
But we'll
is
end it on a positive note.
Okay, so no policy takeaway because it's not positive.
Oh, it's not positive.
No, it's not.
Not
All
in
right,
the US,
okay,
at
let's
least.
switch it up. Just one phrase for the day. From your point of view. It could be non-policy, non-legal related. It could be super fun. I'm just going to let you guys freestyle.
I think people should just get more involved. That.
Get more
that is
involved,
my-
okay?
Nearest boss.
Cop out.
Nice.
Nice. I'm trying, we were joking about leave the US, but that's kind of dire. After this panel is probably a happy hour. That's my happy thought of the day.
Yeah.
like that.
Requalify in the UK. Yeah. Education too. I think we've got to educate people more about how the technology works and why the values that that we think are important can be compatible with fair and proportionate regulation.
Richard?
Yeah, near is the boss, and for those who know, they're Bruce Springsteen, kind of born in the Ukraine, maybe can of twist it around a little bit, and not that we want to get into the geopolitics, but I think there are a lot of. I would argue maybe Europe actually was the first to both have and then squander its first mover advantage in this space. Whether it be arguably Bitcoin and many Gnosis, Arweave, Chainalysis, near, but putting that to one side, I think that we need to trust in the power of protocols as a field of innovation, but also ultimately I think we'll see that what people perceive as the kind of Achilles heel of this space will turn out to be its greatest capability, that of compliance, driven by the capabilities of the protocol, and made possible by the whole, should we say, blockchain operating system, the ability to compose applications, including their front ends, and have that just be decentralized and work in a compliant fashion.
Amazing. Thank you all. This was a great panel. Really appreciate your insight. If you guys have any questions after the panel, please reach out to them.
Thank you.
Thank you.